Desk now. Good afternoon, Kimmona. Always a pleasure to chat to you.
Good to be here. Thank you for having me.
Came a lot of noise, a lot of controversy around Oscar being released after 11 months. That's 1/6 of his sentence. Is this standard practice under South African law, or is it unusual at all?
We know that Oscar has been sentenced to 5 years imprisonment in terms of Section 276(1)(I) of the Criminal Procedure Act. Had he been sentenced to anything that exceeds 5 years, this provision would have fell away completely. How it works in practice is that the provision states that where an offender has served at least or a minimum of 1/6 of a sentence, the sentence automatically converts into correctional supervision. Now, there are instances where the conversion is automatic and it changes from a custodial sentence into correctional supervision almost seamlessly. And then, of course, there are other instances, such as was the case with Oscar, where the parole board had to convene to make a determination. So to answer your question in a nutshell, where offenders are sentenced in terms of this provision, the 1/6 minimum sentence is in fact quite common.
All right, so now Oscar will be at home for barely a fortnight, and then he faces an appeal process at the Supreme Court of Appeals next month. Now, if that appeal is successful, we're going to see an elevation of that charge to a murder conviction. What is the minimum sentence scheme for a murder charge, and how good are the chances that the appeals court will rule in favor of the state and we will see some kind of verdict change?
Well, if the appeal is successful and if his conviction is escalated or elevated from culpable homicide to murder, the minimum sentence that this carries is 15 years imprisonment. With regard to estimating the state's chances of success, it's difficult to estimate, but what we can say is that, or at least what I would do is, I would imagine, or I would anticipate that the state's success rests in placing Judge Masipa's findings surrounding Dolus Eventualis before the Supreme Court of Appeal. We know that in a recent matter that was just heard by the SCA, in the case of the State v. Humphreys, the test for Dolus Eventualis was quite cogently set out. And it is in fact a twofold test. Firstly, applied to Oscar, did he foresee the possibility that his conduct would result in the death of whoever was behind that bathroom door? And secondly, did he reconcile himself to that possibility? And I think it can be inferred from his conduct that he did in fact. So I anticipate that that's the approach the state will use, and I believe their success lies in that.
All right, there are reports coming in now that Oscar's defense team may try to use South Africa's law on double jeopardy to protect him from yet another murder trial. Are they grasping at straws here, or are they really onto something concrete?
The defense team does have a leg to stand on. There is a South African principle known as double jeopardy, which means, and of course we need to have regard to Section 35(3)(m) of the Constitution of the Republic of South Africa, which states that every accused is in fact entitled to a fair trial, which includes the right not to be tried for an offence for which he or she was already convicted or acquitted. More simply said, a person cannot be tried twice for the same offence. So there is definitely a leg to stand on.
Kimmona, thank you so much for your time on the News Today desk. Always a pleasure chatting to you. That was Kimmona Kannigan. She's director at Kannigan Lanham-Love Attorneys. Moving on to other news now. The trial of the 4 men accused of mugging an SABC TV crew at gunpoint has been postponed in the Johannesburg Magistrates Court. Now, one of the defence lawyers was unavailable to represent